So what are some other defenses that we see in these cases that you need to know about? So your client thinks something was done wrong. So the doctor, remember, first says, hey, why are you suing me? I did nothing wrong. That's defense number one. Then he turns around and says, hey, you, Mr. Patient, you did something wrong too. That's culpable conduct. He turns it on the patient and says, don't blame me, you're the one who screwed up. You caused your own problems. Then he says, hey, if I did something wrong, whatever I did didn't cause or contribute to your injuries. No causation. And number four, they say, if I did something wrong, and you did something wrong, and I caused you harm, guess what? Your injuries are not as bad as you claim them to be. So now they're trying to minimize damages. Those are the key defenses that we see in these medical malpractice cases. All right. I have an interesting question for you. How can I get a doctor in a medical malpractice case to admit in his own words that he screwed up and was careless? Voluntarily. Anybody know? During the course of a lawsuit, in a medical malpractice case, how can I get the defendant doctor to actually admit that he screwed up and do it voluntarily? The answer is using hypothetical questions at a deposition. So here we are. We're now in the middle of a lawsuit. We're now in the middle of discovery. I now have an opportunity to question the doctor whom your client has sued. All right. So how is it that I'm able to ask hypothetical questions? I'll tell you why. I can ask a hypothetical question because, first of all, the doctor is deemed to be a medical expert. Even if he's not. He's, as a doctor who's being sued, the law considers him to be an expert, which means I can ask him leading questions during a deposition. I don't have to ask him open-ended questions. Doctor, tell us who, what, why, when, where. I can now ask leading questions. Now, I'm also able to ask the doctor to assume certain facts to be true. Doctor, I want you to assume that Mrs. Jones presented to your office on January 1st with the following complaints of A, B, and C. Would you agree that in that instance, good medical practice requires that you do X, Y, and Z? He has to say yes, because that is good medical practice, and I'm just using this as an example. Now, I flip the question around. Would you agree that a doctor who fails to do X, Y, and Z in that scenario, that would be a departure from good and accepted medical care? And the doctors never, ever want to answer that question. They always turn to their attorney and say, do I have to answer that? And the answer is yes, they have to answer that question. Why? Because it's not one of the three things I asked you at the very beginning. What are the three things that the doctor does not have to answer? Privilege, palpably improper, and things that he doesn't recognize to be authoritative. But in this instance, it's a hypothetical question. So why am I asking him questions? Why am I asking him to assume these facts? I'll tell you why. Because the facts in a medical malpractice case are always disputed. My client says she made the following complaints of a breast lump. The doctor says, no, she didn't. We claim that the doctor did something improper. He says, no, I didn't. They're always factual disputes. You should know that a trial in a malpractice case involves credibility. The jury is going to evaluate whether our client, the plaintiff, is slightly more likely right than wrong, that what we are claiming is true. It's all about credibility. So now I'm going to ask the doctor, assuming that our version of the facts are true, would you agree that in that instance, it would be inappropriate to do X, Y, and Z? And the doctor ultimately has to say yes. And if the question is phrased properly, he has to say yes. Doctor, would you agree it's good medical practice to take detailed, thorough notes for a history? Yes, I would. So maybe there's a claim that the doctor didn't take a thorough history. And now, doctor, would you agree that failing to take a detailed and thorough and accurate history would be a departure from good and accepted practice? Yes, I would. Terrific. So now I'm going to ask him a whole series of hypothetical questions, all favorable to us. Why? Because we are now using our version of the facts. So why is that important? It's important because now, as we get to trial, we're at trial. What is the jury evaluating? Which version of the facts they believe. Which one? Do they believe the doctor's version? Or do they believe our client's version? If the jury believes my client's version, guess what? The doctor has already testified and admitted that failing to do those things, based upon the facts that we had, are a departure from good and accepted practice. Think about that. Think about how powerful a tool this is to be able to get a doctor to admit in his own words that yes, if those things were or were not done, that would be a violation from the standard of care. So it's amazing if the jury believes our version of the facts. Now, you should know something interesting. This tool, this device of hypothetical questions, is not limited just to plaintiffs. The defense has the opportunity to do the same exact thing. And they will often do that at trial, not so much during a deposition of the plaintiff. Okay? But they will ask their doctor questions of facts that are favorable to the defense and using their version. So now the jury will then be evaluating both hypothetical sets of facts. And again, it comes down to who they believe. Does the jury believe our client? We don't have to show that we are 100% true, or the jury doesn't have to show, make absolutely certain that what we're claiming is true. Only slightly more likely right than wrong is the standard. So that's how we get that doctor to do that.